Hi, good evening, everyone. Can you all hear me and you can see the screen?
Yes, we can hear you.
Okay, thank you for the confirmation. Today we are going to discuss about the insurance. So let's go to the subject. And I hope everybody have your FIDIC hard copy with you. Okay, good. So insurance. So why we have the insurance and what are the important if you don't have the insurance, what will happen to the construction project? Ultimately, those are the disadvantage is become advantage when you have the insurance. Okay. So insurance, we have so many risk in the construction. So when come to the construction, we have the so many n number of risks. So who is going to bear the risk? Who is going to take the risk? Sometime one party must take a risk. But if the both party don't want to take the risk, what they do? Okay, they have to share the risk. So this is a situation they have to find a third party person who can share the risk. So basically, what insurance company do? Okay, they share the risk. So therefore, in simple term, it is all about in construction we have plenty of risk. Okay, there may be a loss or damage to the property, or sometime death or injury to the person, or maybe a design risk. So those risks should be covered by the adequate insurance. Okay, so in FIDIC, there are so many provision we have for the insurance. So we should understand today in our lecture series that what is the importance of the insurance according to the FIDIC contract, and you have to check your condition of contract and make sure whether you have the adequate coverage in the insurance. Fine. So the question here, which subclause in the FIDIC 99 Red Book describe the contract defined risk? Okay. Anyone knows? So everybody talk about subclause 18. Fine. Can everyone answer me? So the question is contract defined risk. So which subclause?
Subclause 4.4.
Okay. So subclause 17. If you all go to the subclause 17, title itself, it's a risk and responsibility. There are so many other subclauses. Okay, talk about these risk. So the main subclause, what we can say, subclause 17. The completely the 17s talk about the risk and responsibility, but there are so many other subclauses. We are going to discuss all of them. Okay, so note down the answer for this question. Subclause 17 plus so many others. Okay, that is the answer for this question. Have you all note down? Subclause 17 plus so many other subclauses. Okay. So now when you go to the subclause 18, it talks about the insurance. As you know, insurance to cover the risk. So we'll go to the subclause 18.1. What is the page number?
53.
53. Okay. So carefully, let's read this one. In this clause means this condition of contract. Insuring party means for each type of insurance, we will understand, okay, what are the type of insurance available. So each types of insurance, the party responsible for effecting and maintaining the insurance. That means you have to keep the insurance until some period. Okay, specified in the relevant subclause. So wherever the contractor is the insuring party. Now you should understand this particular subclause. Do you think all the time contractor is the one going to insure all the construction project? Yes or no? All the time?
No.
Okay, then who else will insure?
Client or employer. We have the car risk insurance. Contractor always also they give.
Also, designer, they have the professional indemnity insurance.
PI insurance, car insurance, workman compensation insurance.
Okay, okay. Let's speak only specifically for that question I asked. Is the whole project insured by the contractor? Answer is no. Sometime employer do. Sometime employer do. Why? Sometimes he might have the umbrella cover, where they don't want the insurance from the contractor. Otherwise, wherever the contractor is the insuring party, each insurance shall be effected with the insurer and in terms approved by the employer. So there is a terms and condition. These terms shall be consistent with the terms agreed by both parties before the date of letter of acceptance. That means before you sign the contract, before you send the letter of acceptance, you should agree the terms and condition. Okay. These agreements, okay, of terms shall take precedence over the provision of this clause. So wherever the employer is the insuring party, now see this one. Sometime contractor insuring, sometime the employer doing the insurance. So wherever the employer is insuring party, each insurance shall be effected with the insurer and in terms consistent with the detail annexed to the particular condition. So what does mean insuring party? What do you mean? The answer for this.
Policy.
Some people might having noisy, so just keep it mute. Okay, whoever understood, tell me the answer. What do you mean by insuring party? It is already there in the 18.1. Okay, you don't need to search the answer. Insuring party means the party responsible for effecting and maintaining the insurance. That is the answer. You understand? You have to stick with the contract. So you don't need to give your own definition. It's already defined here. So what is the insuring party? You can mark this answer. This answer you have to take it down. Okay, this answer which I have marked here. This is the answer for this. Okay. Then the second question we can ask: when party must agree on the terms and condition for insurance? When they have to agree?
Before the date of the letter of acceptance.
Exactly. Before the date of acceptance. So that answer is here. After signing the contract, you don't do that way. Then you have to reprice it again. That is not easy way. We have now answer for this, isn't it? Before the date of letter of acceptance, the both party must agree. So 18.1. Okay, have you all marked this whole point whichever I highlighted here in your video?
Yes.
Okay, good. Now 18.1. If a policy is required to indemnify a joint insured, the cover sale applies separately to each insured as though a separate policy had been issued for each of the joint insured. If a policy indemnify additional joint, okay, if a policy indemnifies additional joint insured, namely in addition to the insured specified in this clause, such the contractor shall act under the policy on behalf of these additional joint insured, except that employer shall act for employer personnel. Additional joint insured shall not be entitled to receive payment directly from the insurer or to have any other direct dealing with the insurer, and the insuring party shall regard all additional joint insured to comply with the condition stipulated in the policy. Previous clause talk about the insurance taken by the each party. Okay. But this one, okay, which this one talk about the insurance one. You understand? So sometime the project will go with that joint insurance. So if you go for an insurance jointly, okay, it's going to be a benefit for both parties some instant. Otherwise, it is not regard. So it is subjective. So you have to check whether your contract, okay, you are going to go for a joint insurance or not. So what is the difference between the liability and indemnity? And what does insurance and indemnity mean to you? Now you should understand this part. We will discuss the answer in the next slide. Okay, so you will understand this particular area. So what is the difference between the liability and indemnity? So answer is in the next slide. Okay, so here, what is the difference between the liability and the indemnity, and what does insurance and indemnity mean to you? Okay, so
Engineer,
yeah,
can you please explain the slide which is before this one? I did not understand exactly the paragraph.
okay. The previous first paragraph you should understand here. This one.
This one I understand it.
Yeah, this talk about insurance can be taken. You should here see whenever the contractor insuring party. This is talk about contractor taking the insurance. Okay, this is talk about the second one. Talk about the employer doing the insurance. You understood this part?
Mm.
Okay. Continually, if you go here, the next slide, this particular slide talk about the joint insurance. That means the both party taking the insurance jointly.
Okay.
Okay, so these provisions are available in the contract. Either contractor do or employer do, or they both do together.
Okay.
Okay, that's all this big subclause explaining. Okay, nothing specific. Okay, so here now liability and indemnity. So what does that mean? Liability refer to the legal responsibility. That means contractual obligation. You understand? So if you have contractor sale, that is a contractual obligation, or employer sale, that is an employer obligation. If they breach their liability, then okay, there will be a lawsuit. So both party must obey the liability. So here I have put the example. Companies are liable to pay employees. So if the employees are not paid, are they able to go to the court? What do you think? Can they sue the employer for not paying them? We have a separate labor code, isn't it? So that means liability. They can't escape from there. Similarly, okay, there are so many responsibility. That's what you should understand, the rights and obligation within the contract. those rights and obligations must be delivered by both parties carefully. Otherwise, you will be having the liable for damage. Okay, the same way, indemnity. What is the indemnity? The indemnity means you have to safeguard others. The contractor must safeguard employer, or employer must safeguard the contractor. So it could be so many points we can talk. Let's say now any error happened by the contractor works. Maybe some default or damage to the works because of the contractor error. Who's responsible to cover? Who is need to rectify them? Contractor, definitely. Right. Let's say you hold put the you have installed the some equipment, or let's say you have laid the tiles, okay, floor tiles, and there are some number of tiles got damaged. So who's going to replace? Definitely contractor must do. It means he don't want to transfer that kind of losses or damage work to the employer. Now let's say the design done by the consultant. Any design error which is caused for some additional work, let's say employer got the designer, where the designer designing a slab with the grade 30 concrete. But actually that grade should be 40 instead of 30. Otherwise this grade 30 is wrong. Now the already slab is okay, slab work is done. But later on understandable that this is a fault of the design, and we have to remove the already constructed slab, and you have to replace with the grade 40 slab, let's say. Now look at this work, construction work to be done again. So who's going to pay this, all the cost? Who's going to indemnify this, all the cost? Ultimately the design responsible team, which is consultant. So that means the one party trying to prevent any harm or damage or loss to the other party. This is called indemnity. But both are governed by the law. Okay. So now when you go to the 17.1, we can understand more about the indemnities. So what is the page number?
50.
50. Okay, so we have to understand some important point here. Okay, so but the contractor sale, what do you mean by contractor sale? Contractor responsibility, obligation. Okay, contractor shall indemnify and hold harmless the employer personnel, and the respective agent against and from all claims, damages, losses, and expenses, including legal fees and expenses, in respect of. So it's saying the number of points: bodily injury, sickness, disease, death of any person whatsoever arising of or in the course of or by reason of the contracted design, if any, the execution and completion of the work, and remedying any defects, unless attributable to any negligence, willful act or breach of the contract by the employer or employer personnel or any of their respective agents. So it says very clearly here, contractor shall indemnify and hold harmless the employer personnel. But there are exceptions given here. If anything negligence or purposefully the employer or employee agent do, the contractor don't care about this. He don't have any responsible. The second point say damage to or loss of any property or real or personal other than the work, to the extent that such damage or loss arise out of or in the course of or by reason the contracted design, if any, the execution and completion of the work, and remedying any defects, and is attributable to any negligent, willful act or breach of the contract by the contractor. Now look, this similarity are this says you have to be careful with the okay, employer personnel. So 17.1, okay, is something we have to note down. If anything went wrong, let's say contractor shall indemnify or hold harmless the employee. Now what happened? There are somebody got the injury at site because of the contractor poor workmanship. There was some health and safety issues happen, and they have to be taken to the hospital and they have to treat it well. Who's going to bear this cost? What do you think? Contractor, isn't it? Now assume that contractor didn't care about that one. He don't care. Okay, one employer personnel got injured and he doesn't care. Now who's going to now take care? Contractor didn't do his obligation. So who must do now? To whom he is working for, isn't it? So employer take him to the hospital and he got the treatment, everything. Now he wasted his time and the money. So who need to pay this amount? Who's actually supposed to do this? Yeah, definitely contractor, isn't it? So here, do you understand the contractor didn't do his obligation? So in that case, is there any provision given here in the subclause about the contractor or employer claim? In case somebody not in their responsible, there's no provision given here, isn't it? So this clause you have to note down if you have space there. You have space. This clause not mention either contractor claim or employer claim, but still there could be a claim under this subclause. You will understand this subclause may trigger some claim, but it doesn't mention anything about the claim. Okay, can you note it down there? So if you are having your own condition of contract, maybe you can add the claim provision here in case somebody not following their obligation. This is one of the hidden claim area. Okay, continuously we will read. Now, same way, this subclause 17.1 is not biased to the employer. It's also talk about the contractor also. So the employer shall indemnify. Now it's talk about the contractor side. So employer shall indemnify, okay, and hold harmless the contractor's personnel, and their respective agent against and from all the claims, damages, losses, and expenses, including legal fees and expenses in respect of one, okay, bodily injury and the matter which liability may excluded from the insurance cover. First point is common. Now, what second point talk? When you are entering to the condition of contract, when you are signing the contract, before letter of acceptance you have to agree the terms and condition, isn't it? So when you agree in the terms and condition, okay, some terms excluded from the insurance coverage, so those should be, you know, managed by the those should be managed by the contractor. Otherwise what will happen? He is going to lose the money. So what the subclause say, whichever not covered in your insurance term, those should be managed by the employer. Otherwise, later on, the employer come and say, no, it is insurance, your responsibility, you have to cover all the losses. But there is a limitation given here. So as per the terms and condition, the contractor will bear the risk. Now you should understand one thing. Construction is a business, isn't it? Construction is a business. So contractor ultimately pricing everything, whatever he is spending, backward to the client. He is not here to do any free charity to the employer. So therefore, what it is says very clearly, insurance coverage only the contractor will cover. Otherwise, no. Okay. as described in subparagraph D1, 2, and 3 of subclause 18.3 against injury to the person, damage to the property. We will learn about this in upcoming slides. Okay, so it's very clear this 17.1, it is very reasonable subclause, except one particular point. What is that? You should have the provision of claims in case one person not obeying the condition of contract. Okay, is it clear for everybody? Okay, now let's move to the next one. 18.1. Go back to the 18.1. So it says each policy okay, any question we will discuss at the last. Now listen, because there are so many things to understand. Each policy ensuring against loss or damage shall provide for payment to be made in the currencies regard to rectify the loss or damage. So remember the currencies in one condition of contract, there's a particular currency always mentioned for a payment, everything. If it is more than two different currency, that also should be mentioned. Okay, so currency is very important. So the relevant insuring party sale within the respective period stated in the appendix to tender, calculated from the commencement date, should okay, they have to do submit to the other party first evidence that the insurance described in the clause have been effected. What do you mean by you must prove that you got the insurance for this project? Okay, second, copies of the policies for the insurance described in the subclause 18.2. Insurance for the works and the contractor equipment, subclause 18.3, insurance against injury to the person and damage to the property. One learn that particular subclause. So what it says, you have to give the proof. When each premium is paid, okay, every time you have to pay the insurance premium, the insuring party shall submit evidence of payment to the other party. Whenever evidence or policies are submitted, the insuring party shall also give notice to the engineer. That means they say the project got delay. Okay, do you need to extend the insurance validity period or not?
I guess you should.
Yes, so you have to. Now, if it is a contractor insuring the project and the project delay by the employer, what do you think? The employer must pay for the extension of this insurance?
Yes.
Yes. Otherwise, who's going to bear this loss? Right. But luckily, we have a provision here. 18.1. Okay, at the last of the paragraph, it says about the employer claim and the contractor claim. Therefore, that provision is given. But in the 17, subclause 17, it is not there. Okay, so it is claimable. Now, contracts regard insurance. You understood? Why? Because sometimes that insurance, a design error happen and you have to demolish the project and you have to rebuild it. Do you think the design company is having that much of money? They definitely don't have, isn't it? So therefore, they can't take such a risk. So who's taking the risk? Insurance companies, they do. Contract regard insurance to manage the risk. So all form of contracts regard insurance for the work under the construction. Okay, such insurance cover any damages to the work. Number one, damages to the work or material or plant and equipment or accident. So you should understand there are work may be insured, material may be insured, plant and equipment may be insured, accident happen, okay, should be insured, or any damage by the weather, of any damage by the fire or any damage by the water, okay, it should be insured. But definitely the insurance don't cover the contractor errors. They have some kind of terms and conditions. Okay, some instance it cover, but not all the time. So the wording of the insurance clause, okay, wording of the insurance clause in the contract and the policy, you should understand the policy will dictate what can be claimed and what is not covered. Do you see that one? In the bullet point, they will mention under this particular insurance what you are eligible, what you are not eligible. You understand? So what will do? What you will do? You have to carefully read the insurance policy. Okay, what is covered and what is not covered. Okay, so the insurance will cover the direct cost only. Okay, but will not cover full damage or indirect loss, EOT, consequences losses. These things will not cover. We will understand why it is like this. So there are circumstances where the insurance will cover the direct cost of an event. Okay, let's understand the scenario. Say insurance for the personals. Now one labor, or let's say some people, around 10 laborers working in the scaffolding area, where the scaffolding got collapsed and 10 people got severe injury and they have hospitalized. Now what insurance will cover? Tell me here.
Workman
What
compensation insurance.
Workman compensation, but what this insurance will cover? Medical expenses is very good. Yeah, they are going to cover the medical expenses. Yes or remember one thing, not fully the all medical expenses. Sometimes they have the exclusion also. Maybe there are some kept. You have to pay some amount. They will pay some amount, like 80 on the insurance policy. So this insurance will cover the some of the direct costs. Sometimes not fully you can reimbursement. Now let us understand what is not going to be covered. So let's say it's like iceberg. Everybody keep the mic mute. I allow the time for you to discuss. Okay. So now look, it is called iceberg. What is iceberg? You see the small portion of this iceberg, isn't it? Which is visible for your eye. Small percentage of the work you are seeing here. Now what about the big area? Can you able to see? You can't see because it is below the water. That's called iceberg. Now what insurance can cover? This person, not this one. Now let us understand the incident. How many labor got injury? 10 labor. Right. So when the 10 laborers got the injury, the insurance will cover only the medical expenses based on your terms, what you have said in the insurance. What is approved or agreed in the insurance. Now, what is not going to cover? Look, now 10 people left the site. Do we have the productivity issue now at the site? Yes. We have the productivity issue. Productivity means 10 people works are going to be delayed. So ultimately, what is the risk now for the contractor? If the productivity got slow, delay the project. Yeah. If you delay the project, what will happen at the end of the project? LDS, liquidated damage or delay damages will be imposed on the contractor. Now, that is a good symptom for a contractor. You got the delay in the project completion, and also you are going to pay the money to the employer as a delay penalty. It is not a good symptom. Now, what contractor must do? They have to hire the new people. So hiring is free of charge. What do you think? Is it easy? No, it is not easy. You have to find the 10 people, which is take time. And let's say you hired the people through a recruitment agent. They had availability, so you got the 10 people within a few days. Now let's say this recruitment agent will charge you some amount. So that people also, yes, sometime if you are taking from the different country, you have to think about their travel insurance, right? Accommodation and the medical and also flight ticket, everything you have to pay them. And on top of that, you are going to pay additional salaries, right? Because if this incident nothing happened, you just pay 10 labor salary. Now you are going to pay 20 labor salary. Whereas the 10 people are not coming to the work, but still you have to pay. And other 10, you have to pay for a productivity. So double you are paying. Now think about the newly hired people. Do they know about the construction project, what is going on, where to work, what to work, the productivity? Are you think they can do the same productivity as previous team done at site? No, learning go, very good. You are paying double and getting less. Not only that, during the period, okay, you will lose so many productivity and the money. So those costs are covered by the insurance or not here? No, it is not covered. So insurance just you know uh, a small protection to you. It doesn't cover complete. Let's say about the simple example. Okay,
Sorry,
to understand about
will the contract will the insurance will cover it if the contractor will pay high premium?
no, even it don't cover because the high premium never going to allow another 10 people to bring at the site, paying the recruitment consultant, right? Those things will not there. Even the paying the salary for the injured people, I don't think so. It's always they cover less amount, whereas the contractor will be always going to pay a big amount here. Now think about the vehicle for a simple understanding. Okay, you got a very premium insurance. What I said, very premium insurance, full insurance. Anybody hit you or anybody you hit, it will cover. So let's say you hit the one person vehicle and you had a good insurance. Okay, you hit a one person vehicle and you got a very good insurance. So insurance will cover everything. Now what insurance will cover? Tell me. You hit the vehicle, it's an accident. Okay, let's take in a
They
two
will
three scenario.
cover the damages, but you still have to pay a certain amount.
Let's take a two three scenario. First scenario, you just hit the vehicle. Second, opponent vehicle got damaged, and your vehicle also got damaged. Both went to the garage, and they are repairing. Okay, if you have the good premium, they will give a car for rental. Otherwise, no. So what about this that rental car? You have to go and then take it. That won't cover sometime. Okay, so even you are not covering all the damages. Let's say, okay, a major accident happened. Major accident happened. Maybe major injury to the body. The medical can cover, but let's say somebody go permanent disabled. What insurance can cover? They can go back to your previous life. So what I'm saying here, sometime no, it can't give all the losses or consequences losses or damages happen to the every parties. Insurance just sake of covering some okay some risk. That's all. They also knows very well the insurance company. They are also here to do some business, so they don't take much risk. So the insurance claims like iceberg. You can claim small amount, but whereas a big amount will be you have to be paid as a contractor or employer from your own. Okay. Now let's say particularly the subclause 18.1. If an accident is reported at site, you should know the process. That's what this you should understand. What should you do and how would you file a claim? Now, many people at site they encounter so many issues. Know how to handle them. Let's say accident happened site. Now, let's say one vehicle, contractor vehicle, or a third party vehicle come and hit the constructed wall. So wall is now damaged. Vehicle also damaged. Wall is damaged. Vehicle also damaged. Or sometime the most common claim I have seen. Okay, small claim happening at site. No, always the security gate or the pole what we have at the security damaged by the vehicle. Now let's say any damage happen at the site. What do you do? Can you all can anyone explain if you have experience?
At first, you have to send a notice to the insurance company.
Okay.
At first, you should send a
Then
notice
you
to
have
the
to record.
employer.
Then you have to record the site status with photos, videos, or whatever. And by that, you have to prepare some incident report, because the insurance will request you for incident report, and they will assign like a third party who will come visit on site and assess the damages. And after that, they will assess your claim and comment. And you will agree with them on final amount, which will be paid. This is usually what you are doing.
So if you people never encounter this kind of insurance claim, now this is a procedure. Now you have to give the notice to other party. So if any accident happen, the notice should be given. It should be recorded. If it is an accident is a health and safety issue. So you have to report to the safety team. That's one. Let's say the insurance claim may be a different claim, which is error by the construction work, like a professional indemnity insurance claim. Then that is notice you have to give. So you have to give the notice to the other party something happened, and also you have to inform the insurance company immediately. Okay, you can't inform after some time. Anything happen, you have to have the timeline to inform them. Now you have to keep the records. So records mean maybe take the photos or videos or anything that prove that that incident happened at the particular place. So you have to take the records. Then sometime the insurance need the police clearance. Okay, let's say if it is a vehicle case, then you need the police clearance. Some insurance, some incident. Let's say you damage the work at site, you don't need the police clearance. Depend on the insurance policy. So if needed, yes, let's keep the tick mark, take the records, and if needed, take the police report, if applicable. Okay, that's what I put, if applicable. Second, you have to prepare the incident report. Now every site they have the incident report. So you must have the format already. So you have to take the records and you have to prepare the reports. So all the things will be mentioned in the report. Then wait for the loss adjuster to visit the site and assess the damage. Who's the loss adjuster? The person independent profession who is appointed by the insurance company to investigate and assess the extent of the damage or losses claimed by the insurance. So this party, his role is to gather the information about the incident. He will determine the amount, how much he can pay through the insurance company. So this loss adjuster inspect the site of the incident, interview the witnesses, and review all the document in order to assess the extent of the damage or loss. So they will act as an impartial between the insurance company and the insurance person. Okay, their goal is to ensure that the claims are settled fairly and accurately, and they also refer to the terms and conditions what you have. So this is the loss adjuster duty. So after he done, you have to submit your claim to the insurance company with the all evidence, okay, with the all things. Then they will approve the claim. Okay, so now this procedure slightly may be different, case to case or project to project or based on the insurance policy. Let's say some insurance, what they do, okay, you have to file the notice, and they will ask to get the police report. Then you have to go to the police report. If it is a vehicle, I am telling, then you have to take the car for them to inspect. Then they will value the damage. Then accordingly, they have the third party who can do the repair. They can compensate the amount. Okay, so process will be different, but you should understand how in your company it is happening. How is the procedure that you are claiming the insurance? Now, if you don't give the notice, or if you don't have the records, or if the loss adjuster unable to assess your damages, it is very hard for you to claim. So that's this is a general practice you should understand. Also here, the 18.1, they said each party shall comply with the condition. So do you understand? Comply with the condition. So you have to comply with the condition stipulated in each of the insurance policy. So you should understand what your insurance policy say. The insuring party shall keep the insurer informed of any relevant changes to the execution of the works and ensure that insurance is maintained in accordance with this clause. Neither party shall make any material alteration to the terms of any insurance without prior approval of the other party. Now, if you want to change any terms and conditions within the insurance policy, you have to take the approval of the other party. If the insurers make or attempt to make any alteration, the party first notified by the insurer shall promptly give notice to the other party. So what will happen? Sometime insurance company itself, they are changing the terms and conditions. So in that case, the insurance company will notify, they're supposed to notify the both party, but say some scenario, if it is a joint venture, like, or joint insurance, the both party will get the notification from the insurance company. Let's say contractor insured the project. Now insurance company will inform to whom? What do you think? If any
To the
changes they are doing in the insurance policy?
he did,
Contractor. So once the contractor get the information, then he need to give the information to the employer, or vice versa. If the employer is the one insuring party, then if the insurance company give the information or notice to them, then the employer must give the notice or information to the contractor.
Unas,
All
can
the
you please go
parties
to
to the
the
contract.
slide? Sorry. There is one question I want to ask.
Yeah. I will give a time for you. Just keep all of your question with you. So maybe some of your question will cover in upcoming slide. Okay. So there are so many things to understand about the insurance.
Okay.
So anyone have the question like you, what do you do? Note down the slide number and the subclause if you want. Then we can come back and discuss. So that will be easy. Otherwise, some of your question may be covered by the upcoming slides. Okay. So if the insuring party fail to effect and keep in force of any insurance. Now it says about the validity of the insurance during the project. So if the party, insuring party, fails to keep the insurance effective, what will happen? Or fail to provide the satisfactory evidence and copies of the policies in accordance with the subclause, the other party may, at its option and without prejudice to any other right or remedy, effect the insurance for the relevant coverage and pay the premiums due. The insuring party shall pay the amount of this premium to the other party, and the contract price shall be adjusted accordingly. Right? But contractor failed to do that because of delay happened to the project by the contractor and employer, whatever it is. But anyhow, insurance should be extended. The period should be extended. Contractor didn't extend, or whenever the employer asking the evidence, he didn't provide the evidence for that extension. So now consultant, whoever working for a project, do you need to keep the tracker or log for an insurance validity period? What do you think? Yes, you must. So how do you know insurance going to be? Like we had a tracker or log for a bond. Same way you have to have the tracker or log for the bond insurance as well. So anything going to be expired, the employer must notify the insuring party. Let's say one insuring party is the contractor and he didn't. Is my voice low? Oh, fully audible. Okay. So let's say the contractor one is the insuring party and he didn't insure the extend the insurance validity period. But ultimately this subclause says, okay, contractor didn't do, employer can do, and contractor will pay to the employer. So it's going to be a claim. So it says main contractor failed to produce or unable to produce the insurance, the employer will take it and deduct it from the payment. Simple as it is. Now other way around. Let's say employer is the one insuring party and he didn't renew the insurance or he didn't extend the insurance. What will happen? What contractor can do? He'll pay and deduct from the payment.
Sorry, can you repeat the question because I didn't hear it properly?
You can raise a
Vice
claim for
versa. Vice versa. What I said before. Now employer is the one insuring party, but he didn't extend the validity period. What we can do?
contract can raise a claim. I mean, you can send a claim.
No, the contractor
So this
cannot risk
subclause,
the product without insurance. He should do it. He must do it and then claim it.
so this subclause say insuring party, that could be a contractor or employer. It will be applicable for both the way. Okay, either contractor make it or employer make it. The way is same, no different. The answer is same what we said before. Okay, so what if the contractor failed to procure or renew the insurance? You know the answer. What is your answer?
Employer will buy this insurance or extend, and he will deduct from the contractor's payment.
Yes. Okay, nothing in this clause limit the obligation, liability, or responsibility of the contractor or the employer under the other terms of the contract or otherwise. Any amount not insured or not recovered from the insurers shall be borne by the contractor or the employer in accordance with these obligations, liabilities, and responsibility. However, if the insuring party fail to effect and keep enforce the insurance which is available and which is regard to effect and maintain under the contract, and the other party neither approve the omission nor effect the insurance for the coverage relevant to this default. Any monies which should have been recoverable under this insurance shall be paid by the insuring party. Okay, so look, if you don't have the insurance, let's say the employer is supposed to have the insurance or contractor supposed to have the insurance. Think about the simple way. When you are purchasing the new vehicle, let's say you must have the insurance, right? By law. Yes or no? You must have the insurance. Okay. So let's say you didn't take the insurance full insurance. That means the premium insurance. You just go for a third party at least. Yeah, third party. Now, what will happen? You hit the car. You hit the other car. You are the one person. Okay, did this mistake. So your insurance will cover other party damage. What about your damages? you have to spend your own money to rectify the damages, isn't it? The same way, okay, what did this subclause say? In case any party not comply with their insurance, then they have to bear the risk. Okay, they have to bear the risk. That's what it says. So that's very simple subclause. Payment by one party to the other party shall be subject to subclause 2.5 employee claim or subclause 20.1 contractor claim. It's very clearly say, whereas in the subclause 17 it doesn't say like this. If a certain amount are not insured or recovered from the insurer, who will bear the responsibility according to the content? You have to answer this very carefully. Or who is responsible for the amount that should have been recoverable under the NIST insurance?
I think both parties.
Yeah, who is insuring? So whoever responsible for insurance is the one responsible. The insuring party responsible to pay. That's the answer for this. So just note down. Insuring party is responsible to pay. Okay, have you marked all of them? Okay, some of you answer, okay, if the insurance are not extended, okay, you are going to hold the payment. No, you can't hold the payment. Only one provision is given to hold the payment where the contractor didn't rectify the default. Only such particular estimated amount only you can hold. Other than that, there is no provision for you to given, okay, to hold any payment, but you can deduct the payment from the payment certification. That's available. Okay, so here 18.2, what is the page number?
54.
Okay, all of you go there. The insuring party sale. So insuring party sale, insure the works, plan, material, and the contractor document for not less than the full reinstatement cost, including the cost of demolition, removal of debris, and professional fees and profit. This insurance shall be effective from the date by which the evidence is to be submitted under subparagraph of A, subclause 18.1, general requirement for insurance until the date of issuance of the taking over certificate. So look at this particular subclause. Okay. Until the taking over certificate for the works. What do you understand, anyone?
Until the works are taken over by the employer, the works shall be insured by the contractor.
Okay. Yes. So what did it say is clearly, until taking over the certificate, you have to have the insurance. So once the taking over certificate is given, then insurance can be done. We don't need to have more insurance. That's what it says. But in practically, what will happen? Tell me. If you issue the taking over certificate to the contractor, let's say contractor is the one insuring party, what he will do once you issue the taking over certificate? He will cease the insurance. He will stop the insurance. Then the employer must obtain the new insurance. Okay, if the contractor do. If it is the employer is the one insuring party, then okay, he will keep on continue. But it should be agreed. Maybe you can keep until further extent. Okay, you can go for a performance certificate level instead of taking over certificate. So the insuring party shall maintain this insurance to provide the cover until the date of issuance of the performance certificate. Let's say if the contractor insuring the work or project until taking over certificate, Once you issue, then contractor will cease the insurance. Employer must obtain the new insurance to continue from there. Otherwise, you have to say, Mr. Contractor, you have to take the insurance until the performance set. It is very subjective. Make sure you have to check your contract, what it says. So the insuring party shall maintain this insurance to provide the cover until the date of issuance of the performance certificate for loss or damage for which the contractor is liable arising from a cause occurring prior to issuance of the taking of a certificate, and for the loss or damage caused by the contractor in course of any other operation including under subclause 11 defects. The insuring party shall insure the contractor equipment for not less than the full replacement value, including the delivery to the site for each item of the contractor equipment. The insurance shall be effective while it is being transported to the site and until it is no longer regarded as a contractor equipment. This subclause 18.2, look at carefully. This is talk about the insurance for the works and the contractor equipment. 2 points are discussing here. One is work, another one contractor equipment. So do you understand? There are two different type of insurance are mentioned and the terms and condition very clearly. It's very straightforward subclause, nothing to break your head. But you should understand how many type of insurance this we talk within this subclause. So these are two types here. Have you noted down? One is insurance for the work and insurance for the contractor equipment. Have you noted down these two? 1, 2. Oh, either way. We'll come to the different type of insurance later on. Okay, we are now focusing on the what FIDIC says. Then we'll talk about others.
So this insurance for work, is it the same as a car?
That is different. Contractor all risk. All risk mean every risk covered. Here they define separately. Insurance for the work mean work related risk, equipment related risk. Do you understand? So let us understand what FIDIC says here. Then we will go. So this 18.2 very clearly for the works and the contractor equipment. It is a very long subclause. Okay. So this subclause further says unless otherwise stated in the particular condition. Now look at this particular condition. It is mentioned. So particular condition is then all the changes you are going to do in the particular condition. The insurance under this subclause A shall be effected and maintained by the contractor. So unless otherwise stated in the particular condition. Let's say if you don't want contractor to maintain the insurance, you want to go for an umbrella cover of the employer. Now what do you have to do in the particular condition? Tell me. You have to say 18.2 not applicable. Do you understand? Yes or no? Or not required? Do you all understand? I'm getting less response, whether you are clear or not. Now FIDIC subclause says very clearly, unless otherwise in a particular condition you don't say not regard, the contractor must do this. Shall be in the joint name of the parties who shall be jointly entitled to receive the payment from the insurer, payment being held or allocated between the parties for the sole purpose of rectifying the loss or damage. That means if the insurance company paying some amount, you can't take it and spend for the some other. You have to use it for intended purpose. Okay, in the C subclause C say shall cover all loss or damage from the cause not listed in subclause 17.3 employee risk. So if you go to the 17.3, okay, that's the things we are going to see here. What are the exclusion in the construction contract insurance policy based on FIDIC 1999 Red Book? Now look, 17.3. All of you go to 17.3. There's an employer risk mentioned. What do you mean by employer risk? This risk, contractor don't take any responsibility. Okay. So I have just noted this answer, but you can see 17.3. What is the page number? 51. Very good. It says very clearly, okay, the number 1, war, rebellion, riot, everything, whatever up to the A, B, C, D, E, F, G, H, H. It is employer risk. Okay, this is exclusion from the contractor insurance. They don't care, these all of them. It is employer who want to take care. So you have to make sure what is your exclusion in your contract. Okay. Now let's go back to the 18.2. The 18.2, insurance for the work and the contractor equipment, the D say, shall also cover loss or damage to a part of the work which is, now it's talk about the works, which is attributable to the use or occupation by the employer of another part of the work. Now let's say employee use some part of the work and damage, okay, then it is a risk, or loss or damage from the risk listed in sub paragraph C, G and H of the subclause 17.3. So 17.3, if you see the employer risk, all go back to 17.3. What did it say previously? Okay, so excluding the 17.3, but in the D, it says, okay, C, G, and the H. What is the C? And what is the G? What is the H? You can see.
It's riot, mutation,
Design of any part of the work by the employer, and the H. Any operation of the forces of nature which is unforeseeable. Okay. So this subclause D and subclause, okay, 18.2C shall cover all loss and damage from any cause listed, not listed. Shall cover all loss and damage from any cause not listed under subclause 17.3. This say very clearly, it says, see, it doesn't cover. But when you come to the D, okay, when you come to the D, sorry, here, you have to understand this one. Shall also cover loss or damage to a part of the work which is attributable. Continue, keep on. Okay. See, C, G, and H. Excluding each case, excluding in each case risks which are not insurable at commercially reasonable term. So, it is supporting that particular C. So very clear, employer risk, contractor don't care. Now E may, however, exclude loss or damage. Now it's kind of an exclusion. May exclude loss or damage. Now you know what is the exclusion? 17.3 is exclusion from the insurance policy. Don't cover. Further, it says, okay, and reinstatement. So exclude loss or damage or reinstatement. Let's say a part of the work. What did it say? It is okay. Part of the work which is in a defective condition due to a defect in its design or material or workmanship, but cover shall include any other part which are lost or damaged as a direct result of this defective condition and not described in subparagraph 2 below. So look this one, what it says, if any defect happen because of the design or material or workmanship, okay, do you think it will be covered by the insurance? It's exclusion. It very clearly say, okay, damage happened by some incident, okay, that will be covered. But damage happened by your design. Now design fault, who should be take care PA insurance. Material, that's your problem, right? You bring the material and damage automatically, and you can't come for insurance claim. You must choose the right material. Or workmanship, you did the poor workmanship. Now that poor workmanship was rejected. You can't come under the insurance claim. Do you understand what I'm saying here? Contractor workmanship not good. And the engineer come and did the test on completion, and he is not happy. So what do you think? Contractor can claim the insurance? No, it is not that one. There was an exclusion. Or second, this one, a part of the work which is lost or damaged in order to reinstate any other part of the work. If this other part is in a defective condition due to defect in its design, material, workmanship. So similarly, the E1 is stating here in the E2, and the E3, a part of the work which has been taken over by the employer, except to the extent the contractor is liable for the loss or damage. So if the employer taken over the part, okay, insurance is ceased. You don't need to cover under the insurance. If the insurance, okay, that is having the limitation. If the contractor insuring the work, if the work is handed over to the employer, then insurance is ceased. Okay, the fourth one, E4, goods while they are not in the country subject to 14.5, plant and material intended for the works. Okay, so insurance generally not cover off site material. So you should have the separate insurance for off site material. So very clearly the exclusion given under the 18.2. Okay, so again it is subjective. You have to read your contract. Now anything happen, anybody in this last paragraph, what it says, anything you want to claim, you have to give the notice. Okay, then if it is employer claim, it go for an employer claim, or if it is a contractor claim, it go for a contractor claim. So this 18.2 is not that much difficult. It's look very big, but simple. One party is going to insure until the time which is mentioned in the condition of contract. Okay, it can be taking of a certificate. If not mentioned in the contract, okay, the contractor will do the insurance. And there are exclusions, 17.3 plus, they have given the exclusion under the subclause E. Now, when come to the 18.3, this is something new. So, what we are going to insure under this subclause? Insurance against injury to the person or damage to the property. So, the previous insurance talk about the works and the equipment. Here we talk about the person and the damage to the property. Okay, so this insurance similarly what we discussed previously, the insuring party shall insure against a party liability for any loss, damage or death or bodily injury which may be occur to any physical property except things insured under subclause 18.2. So whatever the things you already insured under 18.2, you don't need to repeat here. Do you understand? 18.2 talk about the works and the contractor equipment. Here it talk about the person and the property. Okay, so the others are simple terms, we don't need to read again. So here we talk about the personal and the property. Now here the insurance against the person and the property. Okay, it is not the contractor personal. Actually, it's employer personal. Or other than the contractor personal. Now when you go to the 18.4, I just skip this one because it is simple. When you go to the 18.4, it is contractor personal. So how many type of insurance now we have in the FIDIC red book here so far? Five under this subclause 18. So insurance for the contractor personnel, what it says here, the contractor shall effect and maintain the insurance against the liability for claim, damages, losses, and expenses. Okay, so the same thing keep on continue. the second paragraph say the employer and the engineer shall also be indemnified under the policy of the insurance. So it's talk about the insurance. So insurance maintenance or the validity should be as per the terms and contract agreed. So again, it's a simple subclause. This is subclause like a water-like subclause. It doesn't have much complication, but look big because it mentions so many important points because to avoid unnecessary argument the later point. Okay. Now we should understand this question. When you are reading the question, don't see the notes. That's what I stop sharing the notes in advance. Do you understand? Sometimes you read the notes. When you receive the letter of acceptance, how do you handle the insurance? When should it be procured? What type of insurance should the main contractor obtain? And what remedies are available if the main contractor is unable to secure insurance? You must know the answer right now. Yes. Talk about all of them. So yes, insurance for the works 18.2, insurance for the contractors plant and equipment 18.2. Okay, third party insurance. What is the third party insurance? Insurance against the person and damage to the property. As I told you, it is not a contractor, personal. And next one, 18.4, contractors workman's compensation. So insurance for the contractor personnel. And you should remember, okay, go to the subclause 4.1. We discussed somewhere before, subclause 4.1. It says under paragraph C, if the contract, okay, can you all go to the page number? What is the page number? 4.1? 12.
12.
Just mark it and mark the C. 4.1 C. Contractor shall be responsible for this part and shall when the works are okay complete. That is C. Right. Okay. So look, that C connected to this one. The last paragraph, you see the fifth one. Okay, very last paragraph before starting A. If the contract specify that the contractor shall design any part of the permanent work, then unless otherwise stated in the particular condition, okay, the contractor shall be responsible for this part and shall, when the works are completed, be fit for such purpose for which part is intended as specified in the contract. Okay, look at this. Anything that he designed and that is not intended fit for the purpose, can we use it? So yes, it's going to be a climb and you have to rectify. So just mark it 4.1, the fifth paragraph plus P, this one C, 4.1 C. Also just these all are connected. Okay, so I just display the answer here. Okay, so you should know the validity and the amount. Okay, if your contracting firm was awarded design and build contract, how would you advise regarding the insurance? So what is the insurance now we have to talk here? How many insurance we need to talk now? Say 6, very good. Not 5, 6. Why? What is the sixth one? The sixth one is the PI insurance. Very good. In addition to the other construction insurances, PI insurance. Okay, that's our answer. Okay. Now, are there any situation where an employer would take out third-party insurance? Have you encountered this before? Or what are the situations in which an employer may take out insurance for works? What do you think?
When the contract is not extending the validity of the insurance for the works.
No. It's all about not the extension of time. Yes, it is all about umbrella coverage. If are there any situation where an employer would take out third party insurance, or what are the situation in which an employer may take out insurance for the works? So look, it talk about third party or work. What did he say? What are the situation employer will no longer need any insurance from the contractor? Now let's say a big project like a airport project, okay? There are number of contractors, okay, or harbor. These are a big project. There are number of contractors for different tasks. If you ask them to bring the insurance for a separately for a project, it's going to be a big amount, because finally who's going to pay the amount for insurance through each and every contract? Employer. So it's going to be a very big cost for him. So what he will do, rather than each and every people bringing the small insurance policies here and there, he will take, no, don't bring any insurance, I will take the full insurance for entire work. That cover all the 5 insurances. That cover all the 5 insurances. Do you understand? Not 6th one. 6th one is a PI insurance. So in that case, he don't want this insurance from the contractor. Is it clear now, everybody? In the same way, I can display the 14th. What does umbrella coverage mean? So do you understand now? Okay. So the answer is here. It is actually profitable to the employer, because rather paying for individual contractor insurance. So umbrella cover for a big project where so many contractor works. So they will do, okay, they will say in the contract, you don't need to bring any insurance. So in the particular condition, they will mention, but they will mention 18, subclause 18, right? They will say 18.2 is not applicable. 18.3 is not applicable. Yes or no? So if it is not applicable, that means you don't need to price it. And 18.4 also not applicable. They will cover it. Okay. Now some people ask about the car insurance. No? What is car insurance? Under which circumstance would you advise management to purchase the car insurance, and why? Now you should understand what is a car insurance mean. What do you mean by car? Don't misunderstand. It's not a car we are driving. Contractor all risk. Contractors all risk insurance. So what is a contractor? How many risks he has as per the FIDIC 99? How many risks? 5, isn't it? If needed, maybe he can go for a 6th, up to 6. Let's talk about the 5. So insurance for the work, contractor, plant and equipment, right? Third party and his workmanship. So they will do what they will do, instead of taking a separate insurance for the work. Okay, 18 point, what is that? 18.2 say insurance for the work, insurance for the contractor equipment, and insurance for the third party or property damage, and insurance for the contractor personnel. What he will do, he will take one insurance that cover all. So this is called car insurance. So some people I hear mistakenly, okay, you talk car insurance that employer is going to take. Am I right? Some people had a misunderstanding. So now I am asking the question, who will obtain the car insurance? Contractor or employer? Contractor. Because it's very clearly say contractors all risk insurance. That means a contractor taking the insurance, but single insurance cover all these type of insurance. Let's say, as per the FIDIC, let's say you took the insurance for 18.2. You took the insurance for 18.3. Now you didn't take the insurance for 18.4 because insurance for the contractor personnel. Now one of the contractor fall down from the site. Okay, he fall down from the high floor area, and he got a severe damage or injury. Now, do you think insurance coverage is there? Do you think health insurance will cover? Basically, no, they don't care about this. Health insurance for normal issues, not for this accident. So who's going to pay now? Contractor will pay. So that's the thing. This insurance, you don't need to go separate wise. You can take all in one. So that is car insurance. Okay. So some people had a misunderstanding. I hope now it's clear. Now you have a fair knowledge of the condition of contract. Is there any risk transferring mechanism allowed on it? Brief about it. What it is question standing for? We talk about the risk, isn't it? So you know that the risk, we have one risk transfer mechanism is insurance. Okay, so yes, you can transfer the risk through the insurance. Also, some risk we can manage by the bond, which is financial insurance, risk. So we have the performance bond. Okay, so do you remember last class we have discussed about all of them? Yes or no? Yes. Okay, so now you understood risk. Somebody should be aware. Risk having so many way to manage. My voice is low. I don't know. Just confirm. Am I audible well? Okay, good. Look, the risk can be managed several ways. Can you mention what are the way we can manage the risk? One is transfer the risk. Where you are transferring the risk? Okay, through the insurance company, you transfer the risk. Or give to the main contractor, give the work to the subcontractor, you transfer the risk. Okay, any other way? Okay, risk transfer, share. Yeah, we can share the risk. So both parties, let's say we share the risk, whatever happen. Or avoid the risk. Don't do this way. You are eliminating, don't do. So that is avoiding the risk. So transfer, share, avoid. Okay. What else? Mitigate. Yeah, we can reduce the risk. So there are so many ways the risk can be managed. So here one of the way we are talking about insurance. What insurance policies are required to be taken jointly for construction project and why? Okay, cross liability. So now we should understand what is a cross liability before we go to the next one. Okay. So cross liability insurance is a type of a policy that can be used in the construction. It allows both employer, okay, or contractor to make a separate claims under the same policy. Okay, if there is an accident or other covered loss. Now this helps to ensure that everyone involved in the project is protected and can avoid dispute. So this cross liability insurance, okay, generally included in a general liability insurance policy, but it can also be purchased separately. So what is the advantage if you have the cross liability insurance? That okay, first, who's involved? That kind of dispute will be avoided. Whoever involved doesn't matter. Okay, cross liability there, you can cover the losses. So both party, it allow both party to make a separate claim under the same policy. You don't need to buy a separate policy by the employer or contractor, and share the financial burden. So it's good, and it is promote kind of a collaboration between the employer and the contractor. So relationship built well, and it's ensure both parties are protected adequately. Don't need to worry. So that's kind of like a team working. That is cross liability. Now we discuss about this subrogation, right? What this terminology come. Sometimes they will ask you this question in the interview. This terminology is simple. Subrogation mean if the injury happen, then let's say anyone can explain the subrogation if you have idea already. What What do you mean by subrogation? Anyone? Who have any idea?
Yes, yes. Now I do insurance with you, and I am the insured party. There are some damages, and I claimed it, and I am entitled. You will pay it for me. Now the insurance party, what you will go, you can go and sue whoever did that damage or caused that damage to me.
Okay, in simple way we will make it understand. Let's say it's a insurance A and it's a insurance B. Insurance A had a cover for one car and insurance B got a cover for another car. It's a vehicle.
Sorry, sir, for interruptions. Your voice is very low, like it's coming from little far.
Is that all for all? Low wise? I'm not sure. Is it clear now?
Now
Is
it
there
is
any
clear,
problem?
sir. Now it is clear, sir. In between, the voice comes very low, like as if you are far from the mic, and suddenly it increases. Then
Okay, just alert me. Okay, I didn't change any position, but maybe it happened by the technical issues. So here, let's say we had a car A and B, and the car A car insurance and car B insurance. Okay, he hit this B. Who's in default? Who's in default? A is default. Okay. So what will happen? The A got the insurance A, and B got the insurance B. This A insurance, okay, will cover the B damage, isn't it? So what they will do, the insurance B, they had an insurance already. So this will rectify all the damages for the insurance B car, and they will call the insurance A to pay them. So ultimately, insurance this car A insurance will be utilized to rectify all the damages of the car B. So this is called subrogation. This mechanism called subrogation. Okay, is it clear? Like for example, you got accident with the one car, let's say. So if you are in a fault, that insurance company, you hit the car, they will rectify the mistakes or all the damages, and they will call your insurance company to pay for the losses. Ultimately, okay, your insurance company will paying that one. So next time if you go and try to renew your insurance policy, what they will do? What they will do normally, because of your mistake, they pay it, right? They will increase the premium. Yes. So what do you do next time if you do something? Then you have to change the insurance policy. They will ask you if you go for insurance for a vehicle insurance. Have you had any accident last year? Definitely that question is there, and they also have the way to check for accident report. Nobody there in the insurance company to do the charity. They do business, so they will check it. Okay, subclause 14.5. This is a one insurance policy we have to understand when you talk about the material offsite. Okay, when you go for a material offsite, this is needed. So all of you go to the subclause 14.5. Okay, page number.
Two and 43.
Okay, so this subclause maybe we'll touch 2-3 times again and again. So here it says, okay, if you have any offsite material, okay, 14.5 B. If you have any offsite material, what is the material offsite? Not in the site, is outside. Then you should have the insurance. Okay, that's what. So you just mark this one. It is for a offsite. So any material, okay, not in site or out of the country or out of the project, then this should be have the insurance. That is called, okay, material offsite insurance. So this is insurance required for if you are having the provision for to get paid for offsite material. Do you understand? So this subclause is needed. But this subclause doesn't apply if you don't have the provision for off-site material payment. Sometimes on-site material, yes, you have the payment provision, but if the off-site material payment given, which is out of the site, it depends. If it is yes, you are going to have it, then you have to have this insurance. If not, then this subclause shall not apply. Okay, so with that, what do you understand from the above subclause? Simple. You should have the provision for the payment. Payment provision not there for offsite material, you don't need. Okay. So we come to the end. Now, if you have any question, you ask me. So any people don't have any question, okay, we can leave. We can leave. Otherwise, you can wait until everybody asking the question. So go ahead if anything miss or any subclause you don't understand.
Sir, I have a question on the car insurance.
Car insurance. Okay, go ahead.
As per the previous slide, it is mentioned that car insurance is covering workman compensation and work and other also third party. But like as in all the tenders which I studied, the contractor in the preliminaries there are all these items are there: car insurance, workman compensation, third party, and these all insurance are there. So then,
Double pricing, isn't it?
and it is not only one tender, sir. From 10 years, I studied more than 100 tenders, and all the projects the same situation: car, workman compensation, third party, and equipment and plant. These all insurances are asking the price.
Okay. So it's look like a duplicated. Oh, we are going to price 2 times. Yes. So clarify next time when you see what is included under the car insurance policy. Then that should not be repeated again. So this is a mistake because see, so many people don't know what is the coverage of the car policy. Okay, they think maybe it's a different policy. Car insurance mean, let's say, maybe some insurance needed only 3 insurance. Okay, or sometimes they go for a 5 insurance as this FIDIC says. Or maybe if you are design and build, we have to go for a 6 type of insurance. Or if you have the material off site, then you have to go for a 7 type of insurance. Or if your project say further different type of insurance, still you have to obtain them. So it is number of insurance depend on the project and the terms and condition you are agreeing. Right. So if you say car insurance, then this insurance will cover everything.
It means client is asking for the double pricing in that case.
Yeah, no, client end up paying double price, not you, he.
Yeah, client. Client is paying the double price for that.
Yes, it's a pure profit, no?
Yes. And second things are similarly, like as insurance are straightforward. Whatever the contractor will buy, he will charge more than the cost to the employer. Then why don't employer prefer to buy insurance at his own? What is the risk to him if he buy it?
Okay. Some project contractor don't do the insurance. They know it is useless, so they will go for umbrella cover. Okay, but some employer is still thinking they want to go for a contractor itself to go for insurance. So ultimately, who is paying? Employer only. But the benefit is there. Look, if they are giving this insurance responsibility to the contractor, okay, they don't need to go here and there for insurance claim, isn't it? So the contractor will manage. Otherwise, all this admin work, record, proof, documentation, loss adjuster meeting, everything to be done by the employee team. So that headache is not there. You understand?
Means only to avoid this administration and this one record keeping and this one. Otherwise, there is no risk to the employer.
Yes. It's kind of a comfort.
Okay. Okay.
Okay. Any other question?
I have one question.
Yes, please go ahead.
One time there was a construction project next to our house, and the bulldozer accidentally crashed my car. But the company just gave me a check with the expenses. But if they will use their insurance, it will be the third party insurance or
Okay, that is happening. Property damage, right? Third party property damage.
yes.
So as
So
per the
it should
FIDIC,
be the third. Mm.
as per the FIDIC, what we said, 18.3 insurance against the injury to the person or damage to a property. So this
Okay.
18.3 damage to a property comes under that particular category. So that insurance maybe cover your losses.
Mr. Munas, I will add something. Sometimes the insurance company will request from the contractor against such property damage to pay much more than the money which she will accept for repairing her car.
Repeat again, what is that?
The one contracting company damaged her car, correct?
Hmm.
Sometimes if the contractor claims through the car policy or the insurance for the property damage, the insurance company will request him to pay a fees that will be more than the fees she will accept to repair her car. So usually the contractors will come and say, just please take this money and fix your car, and that's it.
Okay.
And this
But
is
anyhow,
happening in our
okay. Anyhow, he need to recover that money from his insurance.
Actually, I went to the the people who are fixing my car, and I got a quotation, and they gave me a quotation of the amount, how much they will fix it for. And then I took the quotation, I gave it to the contractor, and he paid me.
Okay, that's proper way.
Cash.
So they
Yeah.
pay the quotation value.
Yes.
Okay.
Actually, they did not pay. They gave me the money. They gave me the amount, and I went to fix my car.
It's fine. Anyhow, they want to compensate you. At the same time, they have the insurance to claim that amount.
I'm not. I don't know. They did not talk to me about any insurance or anything.
Not
I think
only,
they
see,
yeah
not only
they
that.
did not go
Sometimes
to yeah. Mm.
maybe they
Maybe that quotation is request because they will submit to the insurance.
yes, they need to submit the
Maybe
insurance.
later, yeah. Maybe later they will submit it to the insurance.
Yeah.
Yes.
Sometimes the deductible for repairing this is more than maybe the repairing car cost, you know. So sometimes they pay directly instead of claiming through insurance, because if they claim it through insurance, the deductible amount will be higher.
Yeah, exactly. And that's why they are requesting a quotation. So they will pay the market price for that fixing, and that's it. They will close the deal like that.
Yeah. So as a contractor, they know, okay, when they come for operation, third party insurance for the person or property damage. It's happening because sometimes they do the construction, cracks happening in the building because of piling or hammering. Heavy equipments are working next to the building. It happens. So this kind of insurance, okay, will cover such a damages. Okay.
Mr. Munas, can you please clarify the subject of paying, recovering the money from the insurance? Now, if there is a joint insurance, okay, usually there are no two policies by name for each one, correct? It will be one policy, and every name should be mentioned there. So how the payment will be? Usually, as from my experience, we as a contractor receive the payment in a check for the contractor, and no one even asks us about the payment. How much you receive, how much what they will not care unless you rectify all the defects, and they
don't care, because if you don't rectify, then the problem will trigger. Otherwise, let's say you did your work, then other party don't care about it. You didn't do a work, then that is a problem.
Yeah, but I am asking from the professional side, how the payment should be done. Is it correct like that to the contractor and that's it?
Repeat, what was the scenario question?
I am the insurance company, and there is a claim in the project, correct?
Yes.
And I should pay like 1 million. This 1 million, usually, from my experience as a contractor, they are paying it to us under our name. But there is a chance that this contractor will take the money and he did not repair anything, correct?
No, no,
Even
no,
one
no,
person.
no, not like that. They will validate it. That's what it says. The insurance.
Yeah, they validate it very well, and they pay the 1 million. Okay, the 1 million is 100% validated.
In the insurance policy, they will mention very carefully if they are paying the amount directly to you, that should be used for an intended purpose. You can't use it for a different purpose. Let's say insurance company pays some money, contractor took the money and invested somewhere else. No, this is not acceptable.
No, I know. What I am saying is, as a client, I need that bar to be repaired, correct? So, what about making one joint account, and the insurance money should be there, and it should be released by both signatures, both parties' signatures? Is it
Then
practicable?
it is possible, but for a client side, what they need, okay, the rectification should be done. Yes, yes. As long as it's done, they don't need to worry about anything. Otherwise, they still have your performance bond, everything, no?
Yes, yes, correct.
Yes. It will come under the sub clause, if I can remember. Sub clause 11.4. Failure to remedy defects. It's going to be a serious issue. Okay, I forgot to ask, some people already left about the adding extra classes. Okay. Selvi, what do you all think? I think
please.
I suppose. Selvi, ask this question to next class. Maybe we will agree with everybody. I think some of them already left. Why PI insurance client require 10 years of cover period? PI insurance. Okay. Not only PI insurance. Contractor works also. Let's say contractor doing the construction, designer doing the design. Okay. As long as there's a 15 years of client can come and do a claim against you up to 15 years. There's a provision given. Let's say if you are in UAE, you have to manage the claim. Let's say if you have the insurance up to that period, then your insurance will cover. You don't have the insurance, then who is going to bear the losses? Ultimately, you must bear the losses. So therefore, as long as you have a law provision or legal requirement to cover any damages for a certain period, it could be 10 years or 15 years or 6 years, depending on the country, depending on the jurisdiction. You must better keep the insurance validate. Okay, so that is the reason. Okay, now I will ask the same thing what I supposed to ask. Say at least one more classes per week to repeat up this AQS and CM. What do you think? Maybe it can half your period. What do you think?
Yeah, I agree myself. I agree.
I think it will be good. Yeah, it will be better. At least
Instead of 8 months,
Myself
go
also
for a-
agree.
Actually, 8 months is a very long period. So if we can take like 1 or 2 classes and finish it in like half a period, it's very advantage for all of us.
Okay, so we don't want to stress it. If you are increasing the learning hours, like instead of 2 hours, if you are putting 3 hours, I know you people will feel difficulty to learn. You know that one. So rather than that one, what we can do, we can add one more classes weekly till half the duration. So next lecture, we will have all the people. So we will talk to them. Okay, but I will not put the classes during the Thursday. Don't possible. Don't care because I know you have the weekend, and I also have the special classes on Thursday, so I don't put. It will be okay either Sunday. Okay, either Sunday or maybe Wednesday. We will decide later on.
Yes, adding more classes better than 3 hours.
Correct. Yeah. So I feel everybody have
One more,
the,
sir.
yeah.
Sir, month end we are QS working for payment. So So it will be for us, the time will take, we have submission something because I have a month end, we have submission. So try to avoid the month end, but another remaining 3 weeks, you can go for whatever additional classes. Thank you, sir.
Okay. Let's do one thing. Rather than, okay, put last weeks of the month, as you said, or beginning of the month, let's put 2 classes per month in the middle of the weeks. So not in the first week, not in the last week, in the middle of the week.
Yes, sir.
Right.
Yes, sir.
Yeah, that's
So yeah, it will cut, if you do extra 4 classes, it reduce 1 month duration. Do you understand? So if you are okay, one side we are learning the post contract, no? Other side we learn the pre contract. So it's easy for you. So the time go, you can understand fully all the area pre and the post. Then the time also good. So if that okay, we will ask the same question next time, next class. As you said, we are in the last week. Next class is the first week, so still we don't want to put, but we'll ask. If everybody okay, then we will have the classes on middle of the week.
Sir, I have Wednesday another class, so Wednesday not possible.
Okay, then we will keep it on Sunday. I don't think Sunday is problem for
Yeah,
anyone.
Sunday is okay, sir. Sunday no problem.
Sunday is best, Sunday best option.
Good.
Sir,
Okay,
one more
so-
question. 2 weeks back, we received one contract document for review and comments. What is the deadline for submission, sir?
No, there's no deadline given. What I have given, yes, I will send to the new pages also. Now we are learning segment wise new topics, right?
Yes.
So today we learn about the insurance. Last week we learn about the bonds. So what you do, you also go and check that particular bespoke contract and try to sort out or rectify or not all the shortfall in that one. You are going to do the contract review. So once the advanced QS program is end, you already done with your contract review. Then we will have the contract review workshop. There we will discuss each and every sub clauses, where the shortfall, what we supposed to do, like a risk management workshop. Okay. And for
Sir, I
all
have a small
pages, I
doubt.
think yeah, but except 27, I didn't send, so I will send you by today. What is the doubt?
Excuse
Go
me,
ahead.
Mr. Manas.
Uh,
Mr. Manas, I have one question.
Yeah.
Yeah, is this including this batch number 24 also? We can
Yes,
participate,
yes.
or we have any?
I
So
think
we,
I already sent to the 24th already. Have you not received the contract document? Very long back.
no, sir. I have received that contract document. I'm asking about
Every
these extra
one of the,
classes,
yeah,
because almost we are covering all parts and the 24 batch. And can I know which date we can come to the end part, or otherwise we need to participate in your extra class also? That is my question.
okay. I will check and confirm your timetable.
Okay, sir.
Maybe
That
if
will
you
be
covered already some area, then you don't need, because ongoing batch only they started with the post contract. So where they didn't start anything in the pre.
yes, sir. That's
So
why I'm asking, because more than 3, I
but I
think,
will
20.
I
Yes, sir,
will
please.
talk to the next class to everyone. We will agree. Okay, let's have the extra classes. Then once we agree, then we will prepare the timetable. So once timetable prepared, I will share. So in case you want to re-attend it, okay, you can come and attend.
Okay, sir. And exactly what we know about this 24th batch closing date of this batch, and after that we can receive our certificate.
I
No?
have already the revised timetable. Okay,
sure.
done. I supposed to send, so I will send you all.
Okay, sure. I'm waiting.
Yeah, the timetable
Sir,
is
excuse me.
revised. Yes.
So I have a small doubt. I
Yeah.
just want to clarify my understanding on the subclause 18.2. In the
okay.
first, yeah, in the first para, it is saying the insurance should be enforceable until the taking over certificate. In the second paragraph, it explains like, but the contractor has to pay the premium until the payment certificate, right? So performance certificate, sorry.
Okay. The first paragraph say, you're talking about 18.2, right?
Yeah, 18.2.
Yeah. Yes, until the date of issuance of the taking over certificate. Yes. The second paragraph, the insuring party shall maintain this insurance to provide cover until the date of issuance of the permanent certificate. Okay. So this normally what will happen? They will agree the timeline. Let's say ultimately contractor insuring or employer insuring. Employer is the one paying this. Okay. So once you handed over the project to the employer, then thereafter, if you asking the insurance for that handed over part, that is useless from the contractor. So what they will agree in generally, after taking over certificate, contractor you keep the insurance. After taking over certificate, issue it. Okay, employer I will take the insurance. This is what they do the normal arrangement. Let's say
Sir, one
if
more
the
question.
both party, yeah, let me finish him, then I will come to it. If the both party agree, okay, Mr. Contractor, you keep the insurance until the performance area, then contractor price accordingly. Okay, that's the thing. Okay, what is the next question?
Sir, this regarding your unforeseen insurance. My previous project, there was a raining, the damage, the ceiling or something, but I don't know. I didn't work that. Our management talk about the insurance. They will claim on the damage which damage by the rain or something. So is there what this all included this insurance, or we have a separate insurance for that? What is that case, sir?
Okay. See, some insurance, how they are policy which is covered under that insurance, which is not covered under their insurance. Right. So any damages by the water or natural disaster or weather condition, you have to check whether it is covered by the employer risk. Okay. And if it is an employer risk, then definitely your insurance will not cover that one. If not, if it is specifically mentioned, okay, it is covered, then only you can go for it. Otherwise, it is risky. It's like nowadays, let's talk about the mobile phone, right? Normally, water damage. Is it covered by the insurance? They are giving warranty period. What do you think? Company says like Apple, they say no, it's covered. But sometimes Samsung say no, it is not covered. So it depends. It depends on their policy. So you have to check your terms whether it's covered or not. Then you
Sir,
actually
yes, sir. That project was the airport project, so it can be a umbrella coverage. So I think that's why they claimed, but they claimed all. I believe. I checked the all
If it is
documents.
a airport project, let's say from my experience, there was a situation water damage happened to the cameras. Okay, so the employer had umbrella cover. They use it to rectify that works. The contractor rectify, but the insurance company paid because of the umbrella cover, and they have the policy under that water damage. So
Okay, sir.
again,
Okay,
it
sir. I
is
understand.
subjective.
Okay.
You have to check your terms and conditions with the insurance.
Okay, sir. Okay, sir. Thanks, sir.
Okay. Any other questions? Okay then. So I will share the, so as I told you, I will share the contract document to the new people, and also I will share the updated time for old batches. So in next class, just remind me, we will agree the time with every people. We will put extra classes. So we will meet next week. Good night to everyone.
Okay, sir. Thank you, sir. Thank you very much.